3, 2, 1, ready, start. The appellant has asserted that she had been living in the house, as her matrimonial residence, until the application was filed. Stop. Her spouse has, according to her, deserted her and their minor daughter and left them in the lurch. Stop. The electricity to the premises was disconnected for non-payment of dues. Stop. Their daughter has sought admission to an engineering degree course. However, her father, fourth respondent, has not provided any financial support. Stop. The transfers which took place cannot be viewed in isolation from the context of the ongoing matrimonial dispute which has taken place. Stop. The issue is whether the appellant, as the daughter-in-law and the minor daughter, could have been ousted in the above manner. Stop. Furthermore, the counsels for appellant have rightly pointed out Rule 21 small I of Bihar Senior Citizens Rules, 2012, which specifically provides that it is the duty of the district magistrate to ensure that the life and property of the senior citizens are protected and they are able to live with security and dignity. Stop. The present appellant is 75 years old. Stop. It shall be a defeat for the purpose of the Act if appellant is not granted the benefit of eviction against his son and daughter-in-law, who have not only encroached his self-acquired property but also SLP civil number 7675/2024 page 12 of 12 threatened him of false criminal complaints, abusing and creating hurdles in running off the rest house and thereby causing mental and physical harassment to old parents. Stop. However, with utmost respect, the sad decision of the apex court is based on its own facts emerging from the state of Bihar, whereas the case of Samtola Devi Supra arises from the state of UP, wherein, the learned single judge of the High Court in Krishna Kumar versus State of UP had held that tribunal under Chapter 2 could not order an eviction simpliciter. Stop. Even though the sad cases have been decided on its own facts and they do not conclusively hold whether the maintenance tribunal, appellate tribunal, or the authority under the Act of 2007 have powers to order an eviction or not, but Samtola Devi Supra is the closest decision of the apex court, which holds that the maintenance tribunal or the appellate tribunal do not have powers to order eviction. Stop. In light of the above discussions, this court finds that the maintenance tribunal, which is manned by an officer not below the rank of the subdivisional officer or the appellate tribunal which is manned by an officer not below the rank of district magistrate, while discharging their respective duties as a maintenance tribunal or an appellate tribunal cannot go beyond the jurisdiction and powers conferred in terms of Chapter 2. Moreover, in absence of any such power of eviction being expressly conferred on the maintenance tribunal appellate tribunal either by the Act of 2007 or by the rules of 2014, then such powers cannot be imbibed, nor such a power can be exercised under inherent powers, more so, when the tribunals have not been conferred with inherent powers, unlike the civil courts who have been conferred with inherent powers as seen from Section 151 of the Code of Civil Procedure. For the aforesaid reasons, this court is of the clear view that no such power of eviction has been conferred either on the maintenance tribunal or the appellate tribunal in the Act of 2007 or in terms of rules of 2014, hence no order of eviction can be passed by the maintenance tribunal or the appellate tribunal in exercise of its powers in terms of Section 7, 8 and 9 of the Act of 2007. Thus, the questions number 1 and 2 are answered accordingly. Now, before proceeding to deal with the third question as framed, it will be apposite to note Section 20 of the Act, which is a part of Chapter 4, to understand the scheme of the Act as a whole, and for that purpose, Section 20 is being reproduced hereinafter. The aforesaid provision reveals that Chapter 4 of the Act of 2007 comprises of a single Section 20, and it provides for making provisions for medical care and attention for senior citizens and takes within its fold obligation of the state to ensure user-friendly, need-based facilities for geriatric patients in government hospitals. The import of Section 20 in the overall scheme has been noticed in later part of this opinion while dealing with question number 3. Now it's time to consider question number 3, which is being reproduced for the purpose of recapitulation, what is the true scope of Section 21 of the Act of 2007, which deals with protection of life and property of senior citizen, which is contained in Chapter 5 of the Act of 2007, and to what extent the authority can pass an order for adjudging certain transfers as void in terms of Section 23 of the Act of 2007 vis-a-vis the duties and powers of the district magistrate conferred under Rule 21 and 22 of Rules of 2014 and in this context, whether the orders for eviction can be passed.